As it pleases the court, my lord. Oh, they made it down from the second floor. Thank you, my lord. The matter was set down today for a Section 31C application. As counsel discussed with my lord in chambers, the defence is not ready to address my lord on that application, and we, by agreement, request for the matter to be postponed to the 28th. That's Thursday.
Yes. Yes. Yes, Mr. Lunka. I hope you'll hear me. I hope you'll hear me. But if you don't hear, your counsel will explain that to you.
Okay.
We are not going to proceed with the Section 13C application today, but we'll do that on the 28th of May, 2026. You are on to be here. Yes, 10 o'clock. You excuse me.
As it pleases the court, my lord, may I be excused also?
Yeah, excuse me.
Thank you, my lord.
Calling the matter of Fannie Nkosi versus the state with the case number A62, 2026, it's a bail appeal.
May it please court, my lord.
Yes, Mr. Pothuta.
First of all, good morning, my lord.
Yes.
My lord, I confirm my appearance.
Where the kid is? He was
Sorry.
don't even come and greet.
My lord, I didn't know even where to find my lord. My lord, I appear in this bail appeal on behalf of the appellant. With me is my instructing attorney, Mr. Maleo.
Yes.
And then I've got one of the National Bar Council of South Africa's pupils here on my left-hand side. That's a pupil in training this morning.
Yes.
As it please court.
Mr. Mphahlele.
The court pleases. Good morning, my lord.
Yes.
Mr. Mphahlele appearing on behalf of the respondent. I'm with Advocate Sekonyane.
You appear for?
My lord?
You appear for what?
For the respondent.
Yes.
And I'm accompanied by Advocate Sekonyane.
Yes.
As the court pleases.
Are you ready, Mr. Pothuta?
I'm ready to proceed, my lord.
Yes.
My lord, maybe before counsel proceeds,
Yes.
just on the housekeeping issue, it was my wish to see my lord just before the court commenced. However, it didn't happen. The issue that I want to bring to the attention of my lord, which is a request, is that from the previous proceedings in the lower courts, arrangement has always been that the media doesn't show our faces as the state. Instead, our voices, of course, will be recorded, can be heard, but it was our request that our faces not be shown. And therefore, it was going to be my request that when we proceed with these proceedings, faces not be shown, as the court pleases.
Yeah, but I don't know what is the position. Maybe your face has already been beamed. You should have brought, we sent a request tremulously. You never responded. And I don't know what's the position now. I'm not in control of these things.
As the court pleases. My lord, I don't have a problem. We can still proceed,
Yes.
but our faces, whether it has been shown for the past 2 minutes, 3 minutes, I don't have issues with that. But as we proceed, my request is that then my face from now onwards not be shown as I address the court.
Yes. It's also the same position, Mr. Pothuta.
Well, my lord, for me, it's neither here, neither there. I just want to get the appeal done.
Yes, you heard that people from the media. Please don't show Mr. Mphahlele's face. I don't know what's the reason behind that, but it's just making a humble request. Yes. Yes, Mr. Pothuta.
My Lord, before I proceed, I beg leave just to hand to His Lordship two unreported decisions of the Supreme Court of Appeal, which I would refer His Lordship to in argument.
I only received your heads of argument today.
You did not, my Lord?
I only received them today.
Today. My Lord, I would not be able to.
Yeah, but you'll take me through your heads.
Yes, I will do so.
Yes.
My Lord. Yeah, just do that. My Lord, before His Lordship is an appeal. It's an appeal against the refusal of bail by the learned magistrate, Mrs. Teleri. It's an appeal that is governed by Section 65, subsection 1 of our Criminal Procedure Act, Act 51 of 1977. Now, my Lord, the threshold, as I'm aware that His Lordship is aware of, is found in Section 65, subsection 4 of the CPA, and that is that if His Lordship do not find that the magistrate was wrong, then the appeal cannot proceed. But if His Lordship do find that the magistrate was wrong in applying the principles of the law to the facts, then His Lordship is in a position to substitute the finding of the learned magistrate with the finding of the court. We obviously submit, my Lord, that that is the course that His Lordship needs to take. We're going to submit to His Lordship that the magistrate was wrong in her finding in respect of the facts and the law, and that this court is therefore in a position to interfere with that.
I know that you are not involved in a bail application, but from the record I've read that to a very large extent, counsel appearing for the appellant address the merits of the matter.
Yes, in some way.
Yeah, but extensively.
Yeah.
Extensively, and there is authority to the fact that the bail application must not be reduced to a mini trial.
Correct.
And you know, the manner he dealt with the bail application made the state to respond the manner in which they responded.
Yes. I understand that, and that is exactly the principle. And a lot of the findings, my Lord, then comes to credibility findings that should have rather been left to the
Yeah,
trial.
but you are taking the magistrate on that.
Yes.
But you gave him a bread to eat, and after eating that bread, you said, no, you were wrong. You shouldn't have made a credibility finding.
It is so, my Lord.
And it's only to one aspect of the safe not mounted to the hall. He said she's surprised because your clients saw the pictures.
Yes, I understand that, my Lord. But even that is a trial issue, my Lord.
Yeah, but why raise such kind of issue in a bail application?
I cannot obviously provide an explanation. It was.
You can't raise those things and then at the end we said, no, it's trial issue, the magistrate should have closed his ears to that.
Yes, but that would have been the correct approach, my Lord. And unfortunately,
To keep quiet.
that should.
The next thing will be accused of not considering what was placed before him.
Yeah. Well, my Lord, even if she does consider what was placed before her, it must be considered within the bounds of what our law says in respect of a bail application. And remember, my Lord, that a bail application is inquisitorial in nature.
Yes.
So even if there wasn't aspects or facts placed before the court could have inquired in any event and was obliged in terms of the CPA to inquire into certain facts.
Yeah, not to aspects outside the affidavit.
Yes, correct. So, my Lord, and I submit that if my Lord has regard to, I will take my Lordship. The first point that I first also want to make, my Lord, is that both the applicant and the state adduced evidence by way of affidavit.
Yes.
So, they are on par with that, my lord.
Yes.
Now, my lord, I will take his lordship to my heads of arguments, and from page 3 of my heads of arguments, my lord would find the evidence summarized of the applicant before
Page
the bail
6.
court. That's in
Where?
respect.
Page 6.
It's on page 3. It starts on page 3, appellant's case in the bail court, paragraph 13, my lord.
Yes.
And there from on, my lord, will find a summary of the appellant's case in the bail court. In fact, it's a summary of what is his personal detail, his property, immovable property, movable property, and so forth, my lord. And then, my lord, there is an issue that the appellant is currently on suspension as a member of the South African Police Service, and that was also placed before the court. My lord, actually, before I went there, I want to just confirm one thing, my lord, and that is, if one have regard to the charges that was placed before the learned court,
Yes.
there's 2 of those charges that relates to Schedule 5 offences. Although it seems from a reading of the judgment that it was only accepted that the possession of the stun grenade, the explosive, in terms of the Explosives Act, was the scheduled offence, but also the charge in respect of Section 6 of the Prevention of Organised Crime Act, the POCA. That's also a charge that falls within Schedule 5 of the...
Yeah, but you agreed that this bill be dealt with in terms of Schedule 5.
That's what I'm getting at, my
Yes.
lord, that it is a bail application that falls within Schedule 5.
Yes.
So that being the case, then Section 11 B is applicable, where the appellant had to prove to the court that it would be in the interest of justice
Yes.
that he be released on bail. Now, my lord, I think it would be prudent if one have regard to the respondent's case in the bail court. And his lordship will find a summary, a comprehensive summary, in fact, from page 7 of the heads of arguments. I've addressed that in paragraph 14 of the heads. And, my lord, I think it is also prudent that the facts that is relevant and that the bail court had to consider was the fact that there was an allegation that a stun grenade was found, that firearms and ammunition was found licensed to the appellant, but not stored in accordance of the Firearms Control Act. And then there were case dockets found, copies of case dockets and original case dockets. And then also what the state alleged is that there was an amount of cash, 52,000 rand found. The appellant's version on that score is that in respect of the stun grenade, he denied that he's got any knowledge of that, and in respect of the offences relating to the Firearms Control Act, he also denied that the firearms and the ammunition was not in the safe. So one must also...
Can I interrupt you?
Yes.
The search and seizure warrant is the creation of problems for your client. And when I was reading the record when the matter was postponed, the counsel representing your client made certain affirmations that he will challenge the search and seizure warrant because it's defective.
Yes.
But I was surprised when I was reading the record of bail. It doesn't indicate that there was an attack on that.
My lord, I've seen that, and obviously, if his lordship has indicated, if you were not involved there, I can't give an explanation.
Yeah, but it's
for
unfortunate
But
It's unfortunate you are bound by
Yes,
by the appeal record.
I am bound by that, yes.
A bail application record, I'm sorry.
Yes, but my lord, I submit that in any event, that whether it was done in terms of a warrant, whether there's an attack on that warrant, that would be a trial issue.
Yes, no, but normally in a bail application where you have made a confession, for example, you said, no, I admit I made a confession, but that confession was not freely and voluntarily made. You just indicate in a bail proceeding and just leave it at that.
Yes.
You don't go into the merits of it. But there's nothing mentioned about this search and seizure warrant.
I saw that, my lord,
Yes.
and unfortunately, I cannot take it on that
I
score
fully agree
further.
with you that it's a trial matter, but you bring it to the attention of a bail court to say that no, but you must know that even if the state is saying it has a strong case against me because of this confession, I'm still going to challenge that confession.
Yeah,
Yeah.
no, I saw that, my lord.
And then if you don't make any mention of it, so you admit that it was a legal search and seizure warrant.
Yeah. My lord, I submit that is an issue, but it is an issue that could be dealt at trial.
Yeah, no, I understand that. Yeah.
But I do understand His Lordship difficulty with the fact that you raise it that it's an issue, but you place no fact before the court why you say it's an issue. I do understand that difficulty of the court. But what I say, my lord, that if one have regard to, and I will come to that, I just want to refer His Lordship to what is the respondent's response in respect of the notion of the interest of justice that one found in, and we're all aware of that, Section 60, subsection 4A to E of the Criminal Procedure Act. My lord, if one looks at the respondent's case in paragraph 14, it's what I've indicated to His Lordship. The first paragraphs is in respect of what was found, alleged by them and where it was found. And then my lord will find in paragraph 15 of the heads the grounds for opposing bail. And that is where I would like to refer His Lordship specifically to demonstrate the approach of the respondents to the bail application of the appellant. In paragraph 15.1, where they stated he didn't arrest suspects linked to carjackings and posing a serious danger to the safety of the public. He further stated that if he's released on bail, he may commit a Schedule 1 offence. And then in paragraph 15.2, I'm just going to highlight what I've highlighted in my heads about it. He has a suspicion to evade trial. And then also in respect of the financial resources that could assist in evading prosecution. And from there onwards, my lord, if one have regard to 15.3, he may interfere with the investigations of the evidence, and he might interfere with them. That's with witnesses, my lord. And then in paragraph 15.4, there's a concern that the appellant might attempt to interfere with evidence, police administrative systems, case dockets or exhibits. And then in 15.5, my lord, raise serious concern regarding possible interference. The reason why I've highlighted all that, my lord, is because from that the only reasonable conclusion that one can reach is that the state says there's a possibility of any of what we say that might happen. They don't provide also to the bail court any substantive reasons of a probability or a likelihood of any of those.
Yeah, but if you go to 15.1, where you highlighted he may commit a Schedule 1 offence, in your view, that is unfounded?
Yes, my lord.
There was a search and seizure operation that was conducted in October. Large sums of money, cash, was found there. 300 and something thousand, if I'm not mistaken.
But
Just give me a moment.
but
And
no,
then there was a subsequent search and seizure that led to the arrest of your client. That was recent. An amount of 52,000 rands was found. And according to the state, the respondent's case is that there was no reasonable explanation why he was in that. So for you to say that he may commit a Schedule 1 offense is unfounded is based on what, Mr. Potgieter?
my lord, firstly, if I may address the fact that the arrest or the warrant in October was specific in nature. If His Lordship have regard to that warrant, it was in terms of the cyber
Yeah,
crimes.
no, I don't have a problem with
Yeah.
that. But the fact that cash was found there
Yes.
is.
But my lord, there's no allegation or charge of a predicate offence.
Yeah, but
So-
you are saying, you must remember we are in a bail,
Yes.
in a bail stage here. You said he may, they are saying that he may commit a Schedule 1 offense.
Yes. But you must first show, my lord,
The possession of unspecified cash, doesn't it fall under Schedule 1?
my lord, it will only fall under Schedule 1 or Schedule 5 for that matter. If you can show that there exists evidence on which you can reasonably accept that the predicate offence can be linked to the cash that are found.
Yeah, but
Otherwise,
you know, there was, I don't know what happened to that matter, whether the case was open or not.
it doesn't seem like that because there's no
Yeah, but what the
offence.
state is saying is that this person has a propensity of committing offenses if he can be released on bail. So I'm saying to you that there was two separate. They are saying it is police from KwaZulu-Natal who conducted that search, and then there's this other one which was conducted recently that led to the arrest of your client.
My lord,
Cash was found.
yes. My lord, I would submit to His Lordship that if there's no allegation of involvement in a predicate offence, the mere finding of the cash is not indicative of an offence that was committed. There could be a suspicion of an offence,
Yeah,
but there must be
yeah, but
factual.
here we're talking about the possibility of committing an offense was released on bail.
My lord, the possibility would not suffice. There must be a probability, a likelihood. And the Constitutional Court, I will deal with that aspect because that is one of the grounds where I said, where I submit that the learned magistrate had it wrong in respect of what is required in terms of the guidance of our Constitutional Court. But if there's no facts placed before the court that cash in your possession comes from a predicate offence, then, my lord, one cannot.
But if you fail to explain the origin of the cash, what
My
does
lord,
that mean?
that explanation should
It
only
is there in the affidavit of the respondent.
it should only be.
It's not my own imagination.
Sorry, my lord.
I'm saying it's there in the affidavit of the respondent. It's not my own imagination.
I know that, my lord, but what I say, my lord, it would only trigger an explanation if the state say, here's evidence that that cash you got from a predicate offence that was committed. Otherwise, my lord, the mere finding of cash
Yeah.
is
Yeah, but why do you keep 350-something thousand in your house?
my lord, if there's a allegation.
You are not a businessman. You are a police officer who's on a salary of 16,000 rands per month.
My lord, if there
I
is.
can't even myself keep that such amount of money because I'm not getting that salary.
Yes. Now, I understand what His Lordship say. My argument, my lord, is that if there's a charge that says this 350,000 rand falls under Section 4 of it requires an explanation from you.
Yeah, but that amount was confiscated.
Yes,
The 360-something thousand was confiscated.
that's correct. I
And
agree with that.
you go on and keep another 52,000 rands.
Yes.
What does that mean?
My Lord, it doesn't simply...
If it was lawful for you to keep that money, you should have challenged the confiscation of that amount, but you never challenge it. So you know that you are not supposed to keep that money. And then you go to 52,000 rands.
My Lord, that alone cannot show that there's a propensity to commit a Schedule 1 offence.
Yes.
That wouldn't be correct to just accept that as on its own to be that. So, my Lord, I've demonstrated to His Lordship in the respondents' affidavit that they've submitted that they merely demonstrate the possibility of any of those crimes to be committed. Now, my Lord, I would like to move on to the refusal of bail by the learned magistrate.
Yes.
My Lord, in terms of the
Where are
motion
you
of-
in terms of your heads?
Sorry, my Lord.
Where are you in terms of your heads?
It's page 10. I'm at paragraph 70.
Yes.
My Lord, and if we have regard, that is the reasons that the magistrate gave for the refusal of bail. Perhaps it would be more prudent for me, my Lord, if I can just first take His Lordship to the legal framework that I would like to refer to, which is on page 15 of my heads in paragraph 59, my Lord. And then, my Lord, I will come back to the magistrate's reasons. My Lord, I start in my heads of argument with the legal framework, and I've referred His Lordship to international legal instruments in respect of the presumption of innocence.
Yes.
And the only reason why I refer His Lordship to this is that I wanted to demonstrate to His Lordship that the presumption of innocence is an international recognized human right in legal treaties and instruments where South Africa is a signatory. So that being the case, my Lord, the presumption of innocence
Yes.
must play an essential role in the determination of any bail application. And I would try to demonstrate that to His Lordship by referring to the case law that I've also handed to His Lordship. And my Lord, if my Lordship has regard to paragraph 59.8 of the heads on page 16.
Page?
16, my Lord, 16. My Lord will see that I've referred there to the United Nations Standard Minimum Rules for Non-Custodial Measures, the Tokyo Rules. Avoidance of pretrial detention. Pretrial detention shall be as a means of last resort in criminal proceedings, with due regard for the investigation of the alleged offence and for the protection of society and the victim. So, my Lord, I've just stated that to show that the regard that one must have for pretrial detention should be very carefully considered by a court, taking into consideration all the facts. And then again, in our African Banjul Charter on Human and People's Rights, my Lord will find that on paragraph 62.10 on page 17, Article 7b, the right to be presumed innocent until proved guilty by a competent court or tribunal. It's also in our, and we're also a signatory of the African Banjul Charter on Human and People's Rights. So, my Lord, the right to presumed innocent until proven guilty is universally protected human right. Now, My Lord, that is why also, His Lordship, it's not surprisingly that one would find the principle of the presumption of innocence in our Constitution. And His Lordship will find that in paragraph 61 of my heads, where I've indicated that it appears in section 35(3)(h) of our Constitution, determines that every accused person has the right to a fair trial, which includes the right to be presumed innocent.
Did the magistrate take away that right from your client?
Sorry, my Lord.
Did the magistrate, bail magistrate, did he take that right away from your client?
That the presumption of innocence
Yes.
is a right that must be considered carefully.
Are you answering my question, Mr. Potgieter?
I'm getting to that, my Lord. So the magistrate only referred to the presumption of innocence once in the judgment.
Yeah, but you are not answering my question.
What is the question, my Lord?
Did the magistrate take away that right
My Lord,
that your client must be presumed innocent? Did he take that right away from your client?
my Lord, there's two instances where the presumption of innocence will play an essential element.
Did he take that right away?
My Lord, the trial right is also the
Did the
presumption of
magistrate
innocence.
take away that right from your client?
Not in the trial right, my Lord.
No,
but-
in the bail judgment.
Yes.
Did he take that right away
It's not
from?
referred,
Because if you can say yes, then I'll find that she misdirected herself. Then I can interfere with this decision.
yes. My Lord, you need to have consideration to the presumption of innocence in your judgment. There's two ways where the presumption of innocence will
Yeah, but
be.
did she take away that judgment, that right away from your client?
No, we're not at the trial, my Lord. You
At
will
the
have
ba-
that right
I'm
at
talking-
trial.
We are at the bail.
Yes,
We are at the bail application stage.
yes.
In
Yes.
her judgment, did
Yes.
it contravene your client's right to innocence?
Yes, correct, my Lord. That's
Yes.
what that's what I
Yeah,
submitted to you.
take me through that judgment and indicate to me where
My Lord,
she misdirected herself.
my Lord, only once did she refer to the presumption of innocence. Once. That is at the end, where she refused bail. She said, taking into consideration the personal circumstances of the appellant and the presumption of innocence, she only referred to that once, without any reasoning why the presumption of innocence at the pre-trial stage is not relevant to the explanation of the appellant or the state. And that's, I submit, is a misdirection. And I will refer His Lordship to the two matters before, and I will demonstrate to His Lordship what I say in that regard. My Lord, then, if one have regard to paragraph 62 of my heads on page 17, I refer His Lordship to State versus Atkinson, the 1991 decision, where the court says an accused person cannot be kept in detention pending his trial as a form of anticipatory punishment. The presumption of the law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. So the presumption is well established in our law. Even, my Lord, as you have regard to, in paragraph 63, to the matter of S versus Stanfield, the learned Traverso J referred also to the presumption of innocence. And that matter is an important matter also, my Lord, because that demonstrates how the court considered the various factors of the interest of justice. And then in S versus Bronco, my Lord, in 64, the fundamental objective of institution of bail in a democratic society based on freedom is to maximize personal liberty. The proper approach to a decision in a bail application is that the court will always grant bail where possible and will lean in favour of and not against the liberty of the subject, provided it is clear that the interests of justice will not be prejudiced thereby. Now, my Lord, if one has regard to S versus Bronco specifically, my Lord will find in that judgment that the appellant was a Portuguese citizen, and he was charged under the Drug and Trafficking Act.
I know of this decision.
Yes. But the reason why I refer to that, my Lord, is I want to demonstrate to my Lord how the court juxtaposed the two explanations. In that matter, the Mr. Odes, who appeared for the appellant, argued that the state's case was in serious doubt. And the court wasn't prepared to accept that. He says it's in serious doubt, but on the other hand, we find that there might be a case to answer by the appellant. But the presumption of innocence is always in favor of the appellant in that matter. And then the court granted bail on certain conditions.
Yes.
So, my Lord, that is what I'm trying to demonstrate to His Lordship. And if His Lordship has regard to the two matters that I've handed now to His Lordship, and that is the matter of Wilkinson. My Lord will see it's the first flag is Joshua Wilkinson versus the state.
Yes.
That's a matter of the Supreme Court of Appeal. Then in that matter again, my Lord, one would find where the court says, and I want to refer His Lordship to paragraph 10 of that matter. The charges against the appellant are indubitably serious. He faces long-term imprisonment if convicted on the more serious charges. 12 of the 13 counts involve alleged activities which form part of racketeering enterprise, of which the appellant is alleged to be part. But he is presumed innocent until his guilt is proved beyond reasonable doubt. And although the appellant is charged as part of a criminal syndicate, his application for bail has to be assessed on his own personal circumstances and on an assessment of the state's case against him. We are required to assess the prima facie strength of the case against him, not to make a provisional finding of his guilt or innocence. The state's case against the appellant appears on the face of it to be fairly strong. A number of accomplices will be called as 204 witnesses. In his second affidavit, the appellant attacked the credibility of some of these potential 204 witnesses who are known to him on the basis that they have a motive to lie due to problems between them and the appellant. The appellant also sought to explain his involvement in the charges, particularly his close association with accused one, Mr. Ross. These allegations form the gravamen of the racketeering charges and the offences relating to the alleged rhino posing. The explanations are hardly convincing, but even in the face of a seemingly strong case against the appellant, what is required is a weighing up of the interests of justice against the appellant's personal circumstances, in particular the prejudice that the appellant may suffer if he is refused bail. After careful consideration, I am not persuaded that the appellant is a flight risk. Now, my Lord, the point that I want to demonstrate is that the court didn't find the explanations convincing of the appellant. And the court also said that the state seemingly has a strong case. So, my Lord, the court is not in a position where it says the state, because they have a seemingly strong case, the appellant is not entitled to bail. It's where there's a balancing between those two rights with the presumption of innocence. So the presumption of innocence is the balancing force in the case of the appellant versus the case that the state in a bail application is put forward. And my Lord, there's in this decision, there's also the decision that follows that is in similar nature is the one that is attached just after that. It's the one of Sayabonga Mooi, also a Supreme Court of Appeal decision versus the state. And my Lord, similarly, in that case, the court and the importing paragraph is paragraph 9 and 10 of that decision, my Lord. My Lord will find that on page 6 of the decision, where it says, despite the investigating officer stating that the state has a strong case against the appellant, the evidence did not reveal this. The state has not managed in a period of 2.5 years to complete the investigation of the alleged strong case in the trial court. And then, my Lord, if one have regard to paragraph 10, the court again says, according to the investigating officer, evidence, the source of all the evidence against the appellant became known on the day of the incident, and therefore there could not have been any difficulty gathering it. And then again on paragraph 11, the court says, the finding contended for on behalf of the appellant that there is no case at all against him is overly optimistic. Again, my Lord, there's the one, it's balanced against the other one, and then the court, on the end of the day, considered all the facts, as well as the fact that Sayabonga Mooi was previously released on bail on matters in the High Court, and the Supreme Court of Appeal granted him bail on certain conditions. And that is exactly, my Lord, the method that one needs to approach in a bail application. So, my Lord, there's 3 cases where the method that the magistrate employed in the appellant's case was differently applied by the Supreme Court of Appeal. And that is one of the reasons why I state, my Lord, that the magistrate was wrong in the way that she balanced the strength of the state's case against that what the appellant has put before the court. My Lord, then I would like to come to page 19. It starts on page 19, and I want to refer His Lordship to the Constitutional Court case of Dlamini. I will just refer to it as Dlamini, but we all know that it's got Dlamini, Dlatla, Uber, and Skitterkat. That's the full citation appears on the bottom of my heads on page 19. My Lord, then on the next page, page 20, and this is in respect of the onus, the point that I would like to drive, my Lord, is on paragraph 69.1, what the Constitutional Court guidance in respect of onus is. It says, it's not geared to arriving at factual conclusions, but designed to make informed prognosis. So, my Lord, what the bail court needs to do is to procrastinate of what the future holds if I would release the appellant on bail.
Yeah, but on whose side does the onus rest?
No, the onus rests on the appellant.
Yes.
But it's not a factual onus, my Lord. And that's the point that I want to make. And if one have regard to what 11b says, my Lord, it says also, like 11a as well, the one says you must satisfy the court after you have a reasonable opportunity to do so, to establish that it would be in the interest of justice that you be released on bail.
By adducing evidence.
Yes, he did, my Lord.
Yes.
Yeah. So I want to place emphasis on the word satisfy, my Lord. Satisfy links with the procrastination of the court and takes it away from a factual analysis of the proof. So, my Lord, a court must actually project itself. What will happen in the future? And then that is the way, if there's facts that support that conclusion that the court can make, of what would happen in the future, then that would be sufficient to satisfy the proof. And again, my Lord, like I've already referred, my Lord, to the strength of the state's case in paragraph 69.2 of the decision of Dlamini, and I've highlighted that portion that is important. Possible guilt. The court hearing the bail application is concerned with the question of possible guilt, only to the extent that it may bear on where the interests of justice lie in respect to bail. The focus at the bail stage is to decide whether the interests of justice permit the release of the accused pending trial, and that entails in the main protecting the investigation and prosecution of the case against hindrance. So that which should be the main consideration, my Lord, is whether the investigation are protected and whether the prosecution will not be hindered if the accused are released on bail. Now, and that is the next paragraph deals with the important aspect here, my Lord, and that is why I've also stressed to His Lordship how the golden thread that runs through the respondent's affidavit, and that is likelihood versus possibility. And the Constitutional Court dealt with that, my Lord. It says, in paragraph 53, it says, less obviously but nonetheless constitutionally acceptable, a risk that the detainee will commit a fairly serious offence can be taken into account. The important proviso throughout is that there has to be a likelihood. It is a probability that such risk will materialize. A possibility or a suspicion will not suffice. So, and then the court proceeds to say at the same time, a finding that there is indeed such a likelihood is no more than a factor to be weighed with all others in deciding what the interests of justice are. So, my Lord, that is where the magistrate had it wrong, because the golden thread through the respondent's evidence brings a possibility or a suspicion. There's not a single fact in the respondent's evidence that provides as a probability or a likelihood that any of the factors will at the end result. And that's a material misdirection of the bail court. And that is the guidance of the Constitutional Court, my Lord. This is what the court had to follow. Paragraph 53 of the Constitutional Court. My Lord, then to touch on that, I've in my heads of argument in paragraph 71, His Lordship will see that I've referred to Siyabonga Moya. I've addressed that already with His Lordship. And then paragraph 72 refers to the matter of S versus Deviant and others, 2012, where Justice Legordi at the time also referred to the presumption of innocence, where he said the court had proceeded from a wrong premise, which made it concentrate only on the seriousness of the offence, without dealing with the case whether if released on bail, the appellants would interfere or intimidate state witnesses, or whether their personal circumstances were such that they would not stand trial. And the court said that was from a wrong premise to approach it like that. And then the court goes on and refers to the facts and the hearsay evidence of the investigating officer, and then says, it also had to bear in mind that there was a presumption that the appellants were innocent. And then the court refers on the end of the day to more than 100 charges to be preferred against the appellants, served to indicate unless the appellants were released on bail that they stood to remain in custody for many years before their case were finalized. The court did not seem to have considered this aspect, and in that respect it acted incorrectly. So it's a panoply of factors that
What is the court saying about the hearsay evidence?
Here the court referred to the what the investigating officer said in respect of what he was told. He said, the court ACU had furthermore relied heavily on the hearsay evidence of the investigating officer stemming from a statement made to the police. So,
Yeah, but what is the position with the hearsay evidence in
That-
the bail application?
that is just what was said in that
Yeah,
matter.
no, I'm asking you.
No,
I haven't
it-
read the boy, you say it's a MOI. I haven't read this decision.
Sorry, my lord.
I haven't read this decision, that's why I'm asking what is the court saying about hearsay evidence?
Yes.
And
The
what
court,
is the legal position? I'm now asking.
yes.
What is the legal position with regard to hearsay evidence in bail applications?
In bail applications, hearsay evidence, because of the sui generis nature of a bail application, is in certain circumstances.
Why do you qualify it with certain circumstances? It is
because-
admissible.
Not in all circumstances, my lord. So if my lord has regard to
In what
S versus
circumstances?
Stanfield,
In what circumstance is disqualified?
my lord, if my lord have regard to S versus Stanfield, in that matter, and if I have to, I will refer his lordship. I will just have to look for it.
Yes.
In that matter, the learned judge referred to hearsay evidence of what was said in respect of the appellant, and she was not prepared to accept that hearsay evidence
Yes.
without more. So that's why I qualify to say in certain circumstances, my lord. And then, my lord, I've referred my lordship to Branco and Atkinson. I've also referred my lord to, in paragraph 75 on page 23, is where I've referred his lordship to
Yeah, you have
Wilkinson,
referred me to this decision, yes.
which I've already done.
Yes, Stanfield you have referred me to as well.
Yeah. And then in paragraph 76, my lord, I've referred his lordship to the well-known authority on bail, a practitioner's guide. And importantly, my lord,
By
where
Van der Berg.
Van den Berg, yes, my lord. The learned author stresses that although evidence is sometimes presented of a long-standing conspiracy to commit a series of offences, bail is most frequently refused on this ground on account of a propensity on the accused part for committing certain offences. It would be confined to serious crimes of violence. A mere unsubstantiated fear or suspicion that the accused will commit further offences is insufficient to warrant the refusal of bail. And then also and there I refer his lordship again to Stanfield's matter.
Yeah,
Where-
you have addressed me with it.
Yes, where I also just reiterate the fact whether the court was not prepared to accept that there's a propensity of committing offences by Mr. Stanfield. And the court there reiterated what would be a propensity, where the court sê 'n lang reeks vorige veroordelings gehad vir soortgelyke misdade. That would be a propensity that the court referred to. I've also then referred to S versus Cook. And the importance of S versus Cook in paragraph 78 on page 24, my lord, is in respect of interference with witnesses, where the court said there was no proof whatsoever that the appellant was familiar with the identity of witnesses or the substance of the allegations. That certain witnesses had already committed themselves to the prosecution would, it seems to me, render it less likely that any attempt to influence them would bear fruit. The ongoing investigation was relevant insofar as one is able to interpret the evidence of the investigating officer in relation to the possibility that new complainants may come forward. That was on the facts too vague a potential to hold against the appellant. So, my lord, the point that I want to make through S versus Cook as well, and it is also proper in the Van der Berg's bail book, is that there must be evidence of actual interference with witnesses. And if one have regard to that, my lord, and you must look at evidence, here in this matter, the appellant appeared before the Matlanga Commission for a number of days. He was subjected to cross-examination for days by senior counsel.
Is that contained in your?
Sorry, my lord?
Is that contained in your affidavit? You are now arguing outside the bail record.
No, he referred to his appearance.
No, they just referred that he testified in the Matlanga Commission.
Yes.
Full stop.
Yes, but what I'm saying, my lord, is and the fact we know that he was at the Matlanga Commission, that was a commission, that is established in the bail application. So, my lord, there's no evidence whatsoever that he tried to influence anyone not to testify at the Matlanga Commission or to testify differently, and that is the point that I want to make. If you say that he's going to interfere with witnesses or with evidence, you would at least have evidence to the fact that there was an attempt of actual interference. And there's no attempt to that regard. And if one looks at the crimes that is listed as the offences here, then it is the police officers that is the potential witnesses for the state in that matter. My lord, and with the greatest of respect to say that he would be able to interfere with police witnesses, that would really be something that cannot happen. So, my lord, if one have then regard to the application of the legal principles to the facts, and you consider what the learned magistrate found, then I submit, my lord, that the learned magistrate was wrong in the refusal. And that's why I have to go back in my It's of Argument, my lord, to page 10, where I dealt with the reasons of the magistrate. And my lord, I would first like to just pause there and indicate that the test, applicable test, is that you must consider all the evidence collectively and then come to a finding whether the appellant satisfied that his release would be in the interest of justice. It's not a piecemeal consideration of each of the factors that appears in section 60, subsection 4, A to E. It's a collective of all the evidence, and that is clearly from the matters that I've also placed before his lordship. And then the reason why section 64A, my lord, and I also want to make this point, and the Constitutional Court also makes this point. Section 64A is not a trially related factor. Only section 64B, C, and D is trial related factors.
What is A saying?
Sorry, my lord?
What is A saying?
A is the one that says that there's a likelihood that you may endanger the safety of the people or will commit a further offence.
Yes.
So, my lord, then the magistrate says that the possession of the stone grenade is a prohibited explosive device, as well as a substantial quantity of live ammunition, 400 rounds. But we know that the rounds is not over the limit for the amount of firearms that he
But why does
licensed.
he have to keep such large amount of ammunition?
Well, if one considered it with the amount of firearms that is licensed.
Just sorry to interrupt you. And the rifle, is it the R5?
No, it's not an R5, my lord. It's something different.
No. The state issued rifle, the R5. According to the 108 inventory.
Yeah.
According to 108 inventory, your client was not issued with that rifle.
Yeah, no, that I accept. That is
Yeah, but it does have ammunition, and to the last extent,
Yes.
large amount of ammunition relating to that rifle.
But my lord, if one have a R5 rifle, it normally carries a quantity of ammunition with it. But even
Yes.
if,
How many rounds?
well, it can depend, my lord.
Can be 62.
It's normally, I think it would be, I can't remember, but it would be 30 or
30.
something like that
Yes.
per magazine.
Mm.
But my lord, even if
Yeah,
it
but,
is
but it doesn't end up there, Mr. Potgieter. Only 5 of those ammunitions found there were found to be police issued because they've got a identifying mark, which is a P at the back of that ammunition. So it means the rest were not police issued.
my lord, the way I understood it, that he had more police ammunition that was issued
No,
to him.
I'm talking about the R5 ammunition.
Yes.
They are saying it's got an identifying mark, which is a P at the back of that ammunition to show to it that it's police issued.
Yes.
And then of the 62, it's only 5 that have a P at the back.
My lord, what doesn't matter whether it's a large
Yeah,
quantity.
no, it doesn't matter, but what I'm trying to say to you is that the rest was not police issued.
Yes. But he's a licensed gun holder
No,
for a lot of
No,
firearms.
that's the
Yeah.
police equipment.
Yes.
He's got his own
Yes.
firearms which are licensed. I don't have a problem with it.
Yeah.
I've got a problem with the state issued one.
But the amount of 400 includes all the ammunition that was found.
I know. There's
So
a
it's-
breakdown that was done by the state.
Yeah.
62 relates to the R5.
Yeah. But my lord, what I'm saying is, if 400 is in relation of all the ammunition that was found, and with the number of firearms that the appellant has got registered to his name, then it is not a large quantity in respect
Yeah, but
of
I
all
mean-
that firearms.
How many firearms is the person licensed to possess?
Well, it's the number that is
I
is
think you were
allowed.
talking about 7 or 5.
No, it's got a lot, Sam. It's 7, yes.
Yes.
My lord. Licensed
Is,
firearms.
is it permissible?
Sorry, my lord.
Is it permissible
Well, my lord,
in terms of the law?
well, the law doesn't restrict you to the number of firearms that you
In the
may
past,
license.
yes.
So
In the
you can
past-
license
in
any
the
number.
past, you will have a hunting rifle, you will have a revolver but with the evolution of the law,
Yeah.
I think there's a limit if I'm not making a mistake.
No, there's no limit, my lord. As long as the South African
Yeah,
Police
those who
Service
possessed,
license you.
those who possessed
Yeah.
pre the evolution of the legislation, those firearms were not taken away from them.
They were all taken.
They were all taken.
He's all taken. So he's got no,
I'm
firearm.
not talking about your client.
Oh, sorry.
I'm
No?
talking about the law.
Yeah.
Before the evolution of the law, the promulgation of this current act,
Yeah.
you could possess as many firearms.
Yes.
And then when this new law was promulgated, if you had 20 firearms, they were not taken away from you.
Yeah.
You could still possess.
Yes.
Yes.
But you were
But
restricted.
look at the licensing of those firearms of your client.
He did possess license for everyone.
They are recent.
Look, my lord, remember that one has to renew that license. So, as long as it's valid,
Yeah.
he's a licensed gun owner. Ammunition versus what his lordship has mentioned, 7 guns. It's not a large quantity of ammunition.
No, that was not my point.
Yeah.
I was talking about the R5.
R5 specific. I understand that, my lord.
But you are bringing it another aspect that I was not interested in.
Sorry, my lord.
You are bringing an aspect that I was not interested on,
What is that, my lord?
of the large quantity.
Large.
Yeah,
Oh,
overall ammunition that was found there. And there are fired cartridges there, which were found. Do you agree?
there was?
Fired cartridges.
My lord, as I remember, there were
No, they were found in the
ammunition found.
They were found in the. Is there in the affidavit? They were found in an ashtray
In the
of
vehicle.
the Passat.
My Lord, I thought it was .38 special
No,
ammunition.
revolver, after firing revolver, will you get a cartridge?
No, it's in the
It's
barrel.
there.
You
I
need to
can,
take it out.
I can look for you in the affidavit of the state.
Yeah. I will have a
Mr.
look.
Patela, am I wrong? In the ashtray, Passat ashtray, you are mentioning that.
I think it's 2 or 3,
Yeah.
3.8. I thought it was
No,
ammunition, but
There's
I'm not.
fired cartridges.
Yeah,
Yes.
I will not differ from His Lordship.
Yes. But another aspect, you don't deny the fact that your client was in possession of his dockets.
No, that's it. Yeah.
You don't deny that.
No, he also didn't deny.
Yes, and then some are stemming as far as 2012.
As far as
2012.
yes, but remember, my Lord.
No, if you can give me an opportunity. And then you explain the reason why your client was in possession, because of his position in the task team.
Yes, national
So,
task team.
Yeah, his responsibility was to assist police stations. I don't have a problem with that. But the fact that those case dockets were found in the Wendy house where unused material is stored. What does that say to you, Mr. Prosecutor?
My Lord, all that it say is that they were case dockets. He is a detective, as he explained. He was driven task team, and what, my Lord, that is.
But those dockets were basically damned.
Yeah, some were copies. They were only.
Yeah, but why didn't he return them to their respective police stations? Because they are closed.
Yes, I can't say that, my Lord. It's something that stands. My Lord, I see that if I can refer His Lordship just to answer what His Lordship has put to me, paragraph of paginated page 56 of the bundle is the affidavit of the police officer, and it's page 7 of 26 of his affidavit. And I'm just going to read paragraph C. It says, there were 4 live rounds of revolver ammunition in the ashtray of the Volkswagen Passat motor vehicle.
Which paragraph is that?
It's paragraph C on page, paginated page 56 of the bundle.
Yes.
There were 4 live rounds of revolver ammunition in the ashtray of the Volkswagen Passat. So it was not fired cartridges.
No, I'll refer to you as well, but I'll look for it this one.
And just to come back to His Lordship, previous question to me, in B he says in the same Passat motor vehicle on the front passenger seat, there were 2 rifle magazines, both loaded with ammunition 5.56 by 45, 1 magazine with 29 live ammunitions, of which 14 of those ammunitions are police-issued ammunition, and the second magazine with 30 live ammunitions, of which 5 of those ammunitions are police-issued ammunition.
Yes.
So that is where His Lordship referred to the number in the magazines that are not police issued.
Yes.
So of 29, 14 were police, the other not. So that's 15. And then in the second magazine, 30 live ammunition, 5 police, so 25 were not. So it's 15 and 25, it's 40 in total that were in, was not police ammunition.
Yes.
My Lord, the reason what I'm trying to demonstrate to His Lordship in Section 64A is that the reasons advanced by the magistrate to find that he posed a risk is the possession of the stun grenade and then the quantity of ammunition and then the storage of the firearm and ammunition in contravention of the Firearms Control Act. And then she makes a credibility finding on his denial. My Lord, those ammunition, firearms, everything were seized by the police. It's no longer in his possession. So it's no longer in his possession. Yes. So he doesn't have anything. The reasons that the magistrate advanced why he would then be a threat to or a danger to society doesn't exist any longer because it was taken by the police. So to rely on that as a reason.
Why was a licensed firearm taken away from him?
Well, the police allege it was stored in contravention of the Firearms Control Act. So, my Lord, I would imagine that there must be an inquiry now in respect of that in terms of Section 11 of that Act. So, what I'm saying to my Lord, the magistrate could not have found, based on the reasoning, that fact, the likelihood that he would endanger society or a particular person of society was any longer a likelihood, my Lord. So she was wrong in the finding in respect of that specific factor. I'm just going to take it as a factor. Then, my Lord, if I can come to the Section 64B, which appears on page 11 of my heads of argument, where the court found that the seriousness of the offence and the potential for a substantial custodial sentence provide a strong incentive for the appellant to evade trial. The court found that whilst the appellant may have personal ties to his community, these factors are further found that because he's a police officer with knowledge of investigation process, further heightens the risk. So, my Lord, firstly, I would like to submit that on the first point, that clearly the gravity of the charge or the seriousness of the charge placed a very important role with the magistrate. And my Lord, and it was also, I think one cannot argue away that in terms of our minimum sentence legislation, possession of an explosive device falls in a category where a first offender would as a minimum, the 15 years must be considered.
Yes.
But for that very same reason, my Lord, I would like to also refer His Lordship to the Explosive Act, which I have attached to that portion of documents I've given to His Lordship, and I want His Lordship to consider the following. My Lord will see that in terms of the charge pertaining to the explosives, the state refers to Section 1, Section 6, and then Section 10 of the Explosives Act. Now, we know that Section 1 is always a section that deals with definitions, and it is so, my Lord, that a stun grenade or a flashbang that is commonly referred to falls within the definition of an explosive device. Yes. Although it's a non-lethal explosive device. But paragraph 6 makes it then the possession of an authorized explosive is then a crime, and then the state relies on paragraph, or rather section 10 of the Act, my Lord, which deals with penalties. Any person who contravenes any provision of section, and this is the important part, my Lord, 7, 8, or 9, shall be guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 2 years. So the reliance on that section by the state, in my submission, is currently misplaced. What rather should be considered, my Lord, if one have regard to section 28 of the Act. The Act then refers to penalties for possession of explosives under certain circumstances. 1. Any person who is found to have in possession or under the control any explosive under such circumstances as to give rise to a reasonable suspicion that he intended to use such explosive for the purpose of injuring any person or damaging any property, shall, unless he satisfied the court that he had no such intention as aforesaid, be guilty of an offence in liable on conviction to the penalty prescribed in paragraph C of subsection 1 of section 27. So, my Lord, even with his possession, one will have to show that the possession is linked to an intention to commit a serious injury. And then if one goes back to 27 to look at the penalty, penalties for endangering safety or causing loss or life, which is obviously not the case here. Then it says, if one have regard to now 28, it says you must go and look at paragraph C of subsection 1 of 27, and that says, if the act or omission causing danger to life or property is willful, he shall, where death does not result therefrom, be liable to imprisonment without the option of a fine for a period of not less than 3 years, and not more than 15 years, and the explosives and apparatus or conveyance used in connection with involved in the act or omission may be declared to forfeit to the state. So, my Lord, what I'm trying to prove is that even though he was in possession of that stun grenade, it doesn't automatically follows that upon conviction, a sentence of 15 years will be the sentence that he would get. So, and that is also, if one have regard to the matter of S versus Cook, that was one of the arguments that the Supreme Court of Appeal accepted in S versus Cook, and criticized the magistrate for accepting that the maximum or minimum sentence would have been imposed in those circumstances. And the same in S versus Broncos, his lordship will know. So, first of all, my Lord, in respect of the stun grenade, I want to submit that as the charge sheet appeared before the bail court, the state have a problem with the charge sheet and with the charge that is proposed in respect of the accused.
Yeah, that's the trial matter.
Yes, but even if one accept that it's a technical error that the state had in the charge sheet, and I'm prepared to accept that, then I say that in terms of the Explosives Act and the penalties proposed in the Explosives Act, it doesn't follow without more that the appellant would, upon a conviction, be sentenced to 15 years. And that would have been a factor which a court should have considered when she relied on the gravity and the seriousness of the offence, and she didn't. Yes. And she was therefore wrong in not doing that, my Lord. My Lord, and then, my Lord, if one have regard then to the likelihood that appellant will attempt to influence witnesses, The court found the reasoning of the court is the possession of the multiple police dockets relating to serious and violent crimes. Those dockets also been seized. Reason that such possession raises a reasonable inference that the appellant has access to sensitive information, including identities of witnesses and investigating strategies. My Lord, with respect the reasoning that he would have now sensitive information, including identities of witnesses, it can't be. My understanding of the reasoning is that the court referred to the name of witnesses in those case dockets, and those are not witnesses against him. What is against him, witnesses, my Lord, is the police officers that conducted the raid and found the items which they allege were in his possession. And I've also
Was in the bail court thinking that maybe those people will be called as witnesses against your client?
there's no reasoning to follow that they would be witnesses
Yeah,
against
because
the client.
their name in those dockets, and nothing happened to their cases. They can be traced and be called as witnesses. There's nothing precluding the state to do that.
Yeah, my Lord.
So
that
I think the reasoning behind that was that he knows the people who are referred to in the case dockets.
Yes. But be that as it may, then, my Lord, I still submit that it doesn't take the case for the state any further. My Lord, I want to refer His Lordship, and I've already referred His Lordship to bail of Van der Berg. And specifically, I want to refer His Lordship to paragraph 145. Of that paragraph, page 145. It's paragraph 9.6 that deals with the risk of interference with state witnesses, the established approach. And I've already referred His Lordship that there must be an actual interference. In the bail book of Van der Berg, he proceeded to say, third, in the absence of actual interference, in the pending case or in a case in the past, well-grounded fears of interference will suffice to block the accused's release on bail. The mere suspicion that the accused will interfere with state witnesses is clearly insufficient. If bail is opposed on the basis of fear that the accused may interfere with state witnesses, such fear will have to be substantiated by means of clear evidence, my Lord. In Bennett, it was held that the proper approach should be that unless the state can say that there is a real risk that the accused will, not merely may interfere, there does not appear to be a reasonable possibility of such interference. And my Lord, that is exactly, if you take that principle and you apply it to the reasoning of the court in the appellant's case, then the court missed the reasoning of the learned authors and misapplied the principle that is applicable to that. And I say that also in respect of that ground, my Lord, that the learned magistrate was wrong. And then I will get to the reasoning that's in section 60, subsection 4, subsection D, that said jeopardize the criminal justice system, likelihood of that. And the magistrate referred to the unlawful possession of the police documents relating to serious offences, unexplained possession of SABC ammunition and equipment, demonstrates a pattern of conduct inconsistent with the duties of a police officer. The court further found it's a likelihood that the appellant may continue to undermine the proper functioning of the criminal justice system. So, my Lord, one needs to take into consideration, and perhaps the magistrate underscored that, is that he has been suspended as a police officer.
But there is a condition to that suspension.
That he should not, yes.
That he must return all the state equipment.
Mentioned in the suspension, and even if that is so, my lord, then that is charges that he needs to face in that regard. But
So that finding, is it unfounded according to you?
yes, the finding of the magistrate is unfounded, that is a reason
But is
in
it
terms
not
of
the
section.
fact that despite the condition which was set for his suspension, he failed to return all the state equipment?
My lord, he was suspended on 28 March.
And then when was
The raid was on
when was the raid?
on the 2nd of April.
Yes.
So it's a
So you are still in possession of the state?
correct.
Yes,
That I accept.
yes.
But what I accept, that doesn't show that would be a likelihood that he would interfere. That likelihood falls away, the fact that he's suspended. Because remember, my lord, what the magistrate says, if he's suspended, he doesn't have access to a police docket now any longer. He doesn't have access to ammunition and to his firearms. That's all gone, my lord. And only on that score, the magistrate then says, that's undermining the judicial process. So, my lord, the point that I want to make further on that, and I want to refer, my lord, still to the bail book, is that the undermining of that comes after he's released on bail. If he commits another offence, that would be undermining the criminal justice system or the bail system. And that is not what is here, my lord. My lord, I want to refer His Lordship to a specific, in that regard, to a specific, yes. My lord, I would like His Lordship to have regard to page 148 of the bail book of Van der Berg. And it's not in...
What edition is that?
Sorry, my lord?
What edition is that? I remember I read that book when I was
The third
doing
edition.
doing my second year at the university.
Now, this is already a third one. There was a second one. I must say the red one.
Yeah.
The other one was a blue
It
one.
was a black one. I read
Yeah.
the black one.
My lord, on that page, 148, it deals with the risk of jeopardizing the criminal justice system, the established process. And then the court, or the authors referred to Lamer CJC writing for the Supreme Court of Canada, stating the following in relation to a section of the Criminal Code. I am also satisfied that the public safety component of section 5151B of the Criminal Code is necessary to promote the proper functioning of the bail system and is not undertaken for any purpose extraneous to the bail system. In my view, the bail system does not function properly if an accused interferes with the administration of justice while on bail. The entire criminal justice system is subverted if an accused interferes with the administration of justice. If an accused is released on bail, it must be on condition that he or she will refrain from tampering with the administration of justice. If there is a substantial likelihood that the accused will not give his cooperation, it furthers the objectives of the bail system to deny him bail. So, my lord, the principle is that it is how you behave when you are on bail, and then you will interfere with the administration of justice if you do not behave whilst on bail. So, my lord, with that being the position in respect of section 64D, I submit with the greatest of respect that the magistrate also erred in that regard. And, my lord, that she was wrong in concluding that there's a likelihood that that would materialize. Now, my lord, I then come to the last circumstance in terms of the interest of justice that the magistrate, in my view, was wrong. And that pertains to section 60, subsection 4, small e, read with section 8A of the Criminal Procedure Act. My Lord, and what the magistrate did not take into consideration, in that subsection, doesn't matter what the reasoning is, it's flawed, because there's two jurisdictional requirements for that subsection to kick in. First of all, she must found that there is exceptional circumstances. And
Is it not 6011A that requires that?
that's 64E, read with 8 capital A of the Criminal Procedure Act. And my Lord, I would like to refer His Lordship to Dlamini in that respect. And paragraph 55 of Dlamini. I'm just going to highlight certain, I'm not going to read and burden His Lordship with everything. It says, ordinarily the factors identified in section 64E and 8A would not be relevant in establishing whether the interests of justice permit the release of the accused. Would not be relevant. Then the court said, there's a widespread misunderstanding regarding the purpose and effect of bail. Manifestly, much must still be done to instill in the community a proper understanding of the presumption of innocence. There the Constitutional Court recognized that. And the qualified right to freedom pending trial under section 35, bracket 1, bracket small f. The ugly fact remains, however, that public peace and security are at times endangered by the release of persons charged with offences that incite public outrage. So the distinction from section 64E, my Lord, with the others is that here the focus is on the public and the public outrage in respect of bail, which there isn't. There's public attention to the case of the appellant, but there's no public outrage that is described as it is described by the Constitutional Court here. And then in paragraph 56, the court said, and in that judicial process, we know that the scheme introduced by the 1995 amendments was not to prescribe, but to guide, substantially ameliorating its bite. If a court or certain courts elevate this particular factor to a preeminence, it should not have that it is not a constitutional issue to be resolved in this court. Courts will no doubt be alive to the danger of public sentiment being orchestrated by pressure groups to serve their own ends. The constitutional principle is clear. A court may, not must, take the factors enumerated in section 8A into account and must do so judicially. And the ordinary appeal and review mechanisms can remedy any undue difference that may be afforded in public sentiment. Then paragraph 57, it is important to note, section 4E expressly postulates that it is to come into play only in exceptional circumstances. This is a clear pointer that this unusual category of factors is to be taken into account only in those rare cases where it is really justified. What is more, section 4E also expressly stipulates that the finding of such exceptional circumstances has to be established on a preponderance of probabilities, a likelihood. So, my Lord, I'm just going to pause there for a moment. So first of all, that is the jurisdictional requirement. The court must first establish that there's exceptional circumstances, that it would be likely for me to impose or to take into consideration this factor. So there must be in the judgment a reasoning and a finding that exceptional circumstances exist. And the court here was at pains to explain that those exceptional circumstances must be narrowly interpreted, only in that rare circumstances. And then the court proceeds. Lastly, once the existence of such circumstances has been established, paragraph E must still be weighed against the considerations enumerated in section 9 before a decision to refuse bail can be taken. Having regard to these jurisdictional prerequisites, the field of application for section 4E and 8A will be extremely limited. So, judicial officers will therefore rely on this ground with great circumspection, in the knowledge that the Constitution protects the liberty interests of all. Incorrect application of the criteria listed in section 4 by elevating one of them unduly is a matter for the criminal justice system to remedy. And then it proceeds from there on. So, my Lord, what I'm suggesting is, and that's my submission, is that the magistrate's reasoning in respect of her finding in respect of 60 subsection 4E must first have been a reasoning and a finding in respect of exceptional circumstances that exist. And once she had made that finding, then you need to consider the factors in 8A and bring that in line with your finding of exceptional circumstances. But once you do that, my Lord, you must consider the fact that 8A and 64E should apply in a narrow sense, a very strict sense. And in that regard, my Lord, on the facts that was before the magistrate in the court of coup, she could never have come to a finding that section 60 subsection 4E was applicable and held it against the applicant or the appellant. And therefore, my Lord, even on that score, she was wrong, and His Lordship is able to interfere with her finding in that regard. Because that finding, that it is applicable, was then balanced in the bigger scale of the balancing of the personal rights in 9 and 10 with the other rights in subsection 64, and then that weighs strongly with the bail court to deny that. My Lord, that brings me to the I'm sure that my Lord,
I thought you were concluding.
I'm sure that my,
I thought you were concluding.
I am, my Lord, I'm now
But
on
it
the
appears
point.
you are starting.
There's one point that I just want to conclude with,
Yes.
my Lord. And I'm sure that my Lord is tired to hear my voice. My Lord, and that is, His Lordship will find that in paragraph 107 of my heads of argument on page 31. The last leg of the inquiry is, as it was described by Kashalia J. and Branca. Finally, a court should always consider suitable conditions as an alternative to the denial of bail. Conversely, where no consideration is given to the application of suitable conditions as an alternative to incarceration, this may lead to a failure to exercise a proper discretion. The appellant has stated under oath that he is prepared to report to the police station. This was not challenged. I was informed by Mr. Hovers that the Edenvale police station is mere 250 meters away, and then the court granted reporting rights. Nowhere in the judgment of the magistrate does it appear that she considered the imposition of suitable conditions rather than the refusal of bail.
But is it a requirement?
It's a requirement in terms of what the constitutional, what the court already found, and I'm going to refer His Lordship also to
Because in one of your grounds for appeal, 43, you mentioned that the learned magistrate further adding that she failed to consider correctional supervision and
Yes.
or house arrest as a suitable condition for bail.
Yes.
Is it not like prejudging your client?
No, no. No, I'll show His Lordship why I've included that. I just want to finalize the one-off conditions. My Lord, that case of Wilkinson, the court, one of the reasons why the court said in Wilkinson, in paragraph 11, the last paragraph, just before the court granted bail in that matter. After careful consideration, I'm not persuaded that the appellant's a flight risk. He has strong occupational person business interest in the country. There is no indication at all of such interest beyond our borders. The imposition of appropriate bail conditions will limit any risk that he may not stand his trial. The appeal must therefore be upheld and accused must be granted bail on appropriate conditions. So, my Lord, bail conditions is unfortunately something that a court must consider as an alternative.
Yes, reporting at the police station, yes. But to undergo programs under the correctional supervision,
My Lord, let me,
it's not like, is it not, because this is a sentencing option.
can I, my Lord, may I refer His Lordship to the Criminal Procedure Act?
Yes.
And Section 62, that's a court may add further conditions of bail. And if one has regard to paragraph, Section 62, paragraph small f, it reads that, so it says, let me just go to back, any court before which a charge is pending in respect of which bail has been granted, may at any stage, whether the bail was granted by that court or any other court on application by the prosecutor and any further condition of bail, and then it goes to small f, which provides that the accused shall be placed under the supervision of a probation officer or a correctional official. So what it says, as a condition of bail, the court is entitled to place him under correctional
Yeah, but is
supervision.
it not like serving a sentence?
No, no, but
because you
it's,
have to undergo certain
no, but it's
no,
distinct
you have to go,
from.
you have to go under certain programs which are meant for convicted and sentenced people.
My Lord, it's in our Criminal Procedure Act.
Yeah, no, I understand it's in the Criminal Procedure Act, but if I effect that provision, would that not amount to prejudging your client?
No, my Lord.
Because
It's monitoring. That's all that it is about. It's monitoring an
so
accused person that's
you
on
monitor
bail.
a person by putting him on programs.
He's not on programs, my Lord.
Yeah, but
They're just monitoring
what does
him.
correctional supervision mean, according to your view?
It means that he's monitored.
How?
In terms of this section, it means
No,
he's
in terms
monitored.
of what we are requesting here, in
Yes.
item 43,
Yes.
what does that mean?
It means exactly what is in section 62F, my Lord.
Yeah, but they are not talking about correctional supervision.
They're talking here of correctional supervision. Accused shall be placed under the supervision of a probation officer or a correctional official. That's correctional supervision.
Does it talk about house arrest?
It falls within correctional
Does it
supervision.
talk about house arrest?
It doesn't talk specifically, but in correctional supervision there is provision for house arrest. And my Lord, I am aware of matters where bail was granted, where an accused person has been placed in house arrest from a certain time in the evening until 4 or 5 in the morning, to be at his house as a condition of bail. So what I'm saying is, as an alternative, and if one looks at the
So
applicant,
is it a misdirection? Not
yes,
to consider that as an alternative?
it's a misdirection if you didn't consider it, my Lord.
How so, Mr. Potgieter?
Because the Act provides for that you can consider it as a condition of bail. So if you do not consider bail conditions
But
at all,
if one is of the opinion that you don't qualify bail at all because of whatever you have put in your judgment,
well, that's not what
does that amount to a misdirection?
that's a misdirection, because you need to consider bail conditions. The court has stated that many times, my lord, that suitable bail conditions must be considered as an alternative to the refusal of bail. And if
Because of the fact that it's a provision in the Criminal Procedure Act. Is that your argument?
Yes, and based on the law.
I'll give you a practical example where a person is found in possession of a firearm. There are so many decisions from the Supreme Court of Appeal up to the Constitutional Court where a person was found in possession of an AK-47, which the law prescribed a minimum sentence of 15 years. But the court imposed 6 years for being in possession of it. Is that a misdirection because they didn't follow the letter of the law?
No, but the court in those circumstances, my lord, would have found that there's compelling and substantial circumstances present. And that is a...
And that's what the magistrate found here, that there's no alternative other than to deny your client bail.
But my lord, what I'm suggesting to his lordship is, my lordship has regard to Bronco. If you have regard to Wilkinson, if you have regard to Moy, all those decisions of the Supreme Court of Appeal says it's wrong if you don't consider suitable bail conditions rather than the denial of bail. If you consider that, then the magistrate was obliged to consider that. If you didn't, it's a misdirection of the magistrate.
So are you saying in each and every bail application, this alternative must be considered?
Yes, my lord. And if it's not suitable, then there must be reasons why conditions of bail would not be suitable.
Yes.
Thank you, my lord. Is there anything specific to his lordship?
It's fine.
Thank you.
Yes.
My lord.
Are you ready, Mr. Mpatlet, or who's arguing?
Yes, I am. I'm just requesting 2 minutes comfort break. I want to answer the call of nature. I was drinking water. My lord.
We'll take a short adjournment, court adjourns.
of the investigating officer. They were not locked. The court asked few questions around the issue of ammunition, and ammunition that was, or let me say used ammunition, used cartridges. My lord, that particular aspect is captured by the affidavit of the investigating officer, where he states that these particular empty cartridges
Which page is that in the record?
of the record is page 54.
54, I remember reading about that.
It's page 54 under paragraph 6.3 E, where he mentions that 6 9mm empty fired cartridges were found, and these were kept in that unmounted safe. It's
Paragraph?
6.3. It's right at the top. Paginated page 54.
Yes.
As the court pleases. And further, my lord, an issue that has been taken up by the state was to the effect that a stun grenade was found. However, the appellant, in his submissions, insisted that there was no stun grenade found at the premises. Again,
Was a photograph taken of the stun?
indeed so, my lord. And
How does it look like? I don't know what is a stun grenade.
my lord,
Which photo is that?
that will be just a moment, my lord. We're using black and white photos, and the original docket has the colorful pictures. Well, that should be page 86
Yes.
of the paginated bundle, photo number 611
Yes.
is the photo at the top.
Then where was this found?
The stun grenade was found
Inside the house or inside the vehicle?
inside the house, my lord.
Yes.
Let me just double check something, my lord.
But it appears to be inside a container here. Is it a locker, a safe or what?
I beg your pardon, my lord.
Is this a safe? It appears to be inside a container.
Yes, it is inside a container.
Is it a safe?
It's not a safe, my lord.
Yes.
My lord, according to the investigators' affidavit, this particular stun grenade was found at the bar in the house. I think the house has got a room, which is a bar. That's where the stun grenade was found. Well, Lord, one other factor which looks like it's been an issue was the police dockets. Correctly so, the court in engaging the appellant counsel around the issue of police dockets. The police dockets were found, and these particular dockets were actually kept in the Wendy house. And as the investigating officer correctly stated, they were gathering dust in the Wendy house. My Lord, these police dockets, one interesting point is that if one has to refer to one of these police dockets, which will be just a moment, which will be Attridgeville, case 11 of 10/2015, which is the docket that was pertaining to car hijacking, wherein fingerprints were lifted at the crime scene, where CCTV footage disc was found inside the docket, where still photos were created from the CCTV footage obtained at the Fidelity Security Company, and statements were taken from the company. This docket, my Lord, according to the information from the police system, and which was confirmed by the archive clerk at Attridgeville Subs, this is a statement which is marked A11 in the main docket now. The applicant signed for this docket on the 21st of June 2016. He kept the original docket until the 2nd of April 2026, when it was recovered during the search. A duplicate docket was opened by Lieutenant Colonel Ramokoka and closed it in the system because the original docket was missing. There is no other reason for the applicant, or there was no other reason for the applicant, my Lord, to keep this docket. And as we stated in our heads of argument, that the aim would have been just to frustrate the investigations and defeat the end of justice. My Lord, there's quite a number of dockets.
Police officers are allowed to keep police dockets in their homes.
My Lord, as far as I know, I think, I'm not so sure, because keeping would be storage, I guess, in the context of the question by my Lord, whether a police officer is allowed to store. I doubt if that would be allowed, my Lord, but as in keeping, because one is going through the docket, is working on a daily basis on the docket, it happens that people carry their job, their work home, and they work after hours. My Lord, may I request that my IO sits here, because there's information that he wants to relate to my colleague.
With regard to the question that I asked,
No. I'm just saying the court shouldn't be distracted that
Oh.
there's a person that came to sit here.
yes.
And my Lord, the other dockets, as we stated in our heads of arguments, Soshangube, case 311, 7/2019, which was pertaining to accessing or intercepting data without authority or permission. The docket was registered at the station and transferred to the head office. It was then acknowledged by Lieutenant Colonel Muchekwa, and is marked A12 in the main docket. According to A12, he does not recall signing or investigating such a case docket. Between 2013 and 2022, he was working with files, not case dockets. He alleges that someone unlawfully used his credentials to acknowledge the docket. And this is the docket that was found in possession of the appellant. In the said docket, the appellant applied for Section 205 subpoenas to obtain call data from cell phone service providers. The station was visited and they indicated that the docket is still under investigation. After 7 years, therefore, my lord, that particular conduct as it stands talks to the issue of defeating the cause of justice. However, I'm addressing those particular issues that the appellant stated that are issues for the trial court. Forgetting that, he is advancing an argument that the state does not have a strong case. And therefore, one cannot leave these aspects out when one addresses that issue of whether the state does the state have a strong case against the appellant. And it is our submission, my lord, as we stated in our ways of arguments, that the state has a very strong case against the appellant. And in Sinoville case 585 of 01/2014, this is also the docket for car hijacking. After the police station discovered that the docket was or had gone missing, Lieutenant Colonel Ramukoka inquired from the applicant about this docket. As according to the system, it was assigned to him on the 9th of April 2015. The applicant's response, or the appellant's response, was that he did not know the whereabouts of the docket. Yet the docket was later found at his place during the search and seizure on the 2nd of April 2026. Lieutenant Colonel Ramukoka had to open a duplicate docket and file it as undetected on the 24th of July 2018. My lord, the investigation was stalled and hindered by the applicant's intentional conduct of denying knowledge of the docket, whereas it was in his custody. These are the issues, or some of the issues, that the appellant says are for trial court, and the state does not have a strong case against him. There's Richard case 671 of 1/2013. This is a common robbery docket where CCTV footage was saved inside 2 discs. A covering letter was written by the applicant applying for analysis of the footage and preparation of album. Elimination fingerprints, 2 sets were taken from Kagiso Hlongwane. Elimination fingerprints were also taken from Sfiso Mthembu, 2 sets, and also an SAP 76, that is for fingerprints of the suspect, Kagiso Joseph Hlongwane, charged in the docket, was also taken. Now, SAP 76 for fingerprints of the suspect were found in the docket, and they were never sent to the local criminal record center for processing according to standing order of the police. Suspect fingerprints, which are commonly called SAP S76, are supposed to be taken to the LCRC within 3 days after being obtained from the suspect. However, the applicant kept them at his place for 10 years without being sent to the LCRC. The last time this docket was before court was on the 7th of September 2016. And it was remanded to the 13th of September 2016 for accused person's attorney, not for the docket. After the said last appearance, there is no way in the docket that shows what transpired or the outcome of the investigation. The last entry on the SAP or SAPS 5 diary was on the 20th of April 2015 by the applicant when he was acknowledging the receipt of the docket on the system and proceeding to Forensic Science Laboratory. Now, this particular docket was closed as undetected on the system on the 6th of February 2013. Yet the docket was in possession of the applicant with all evidence as indicated. My Lord, I'll highlight again another docket, Roodepoort case 26 of 6/2022. This is cash in transit docket. During the commission of this offense, 2 firearms were robbed from the security guards. And another docket, Fannie case 651, 3 of 2014 of carjacking. During the commission of the above offense, a police officer was robbed of his service pistol and cell phone. On the 15th of September 2022, there was a cash in transit robbery at Musina, and firearms of security guards were also robbed under Musina case 203/9/2022. On the very same day of the 15th September 2022, 3 suspects were later arrested for possession of firearms as per Musina 2010/9/2022, and the security firearms which were robbed during the catch in transit were recovered. Now, the applicant arrived at the police station while the docket was being registered and demanded the possession of unlicensed firearm docket to be transferred to his unit at the head office. The applicant demanded the docket in the presence of SABC or DPCI Musina officials who already had a cash in transit docket as per Musina 203/9/22. And he used this office or official superiority to attain the possession of that particular docket. It must be noted that the normal police practice is that possession docket must have been brought together, combined or married with the robbery cash in transit docket. Furthermore, both matters must have been investigated by one unit and not separated as it happened by the applicant's insistence. Now, interestingly, a ballistic report of Musina 2010/9/2022 was obtained, and it was established that 2 of the recovered pistols were robbed from the victims as per Fannie case 651 of 3/2014 and Roodepoort case 26 of 6/2022 respectively. These are the dockets that I started with when I mentioned this Musina challenge. Now, the applicant obtained a said ballistic report. He visited the 2 police stations, being Fannie and Roodepoort, and made copies of those dockets, which were eventually found in the applicant's house. And this, the applicant was duty-bound to charge the Musina suspects who were found in possession of those firearms, but instead he intentionally turned a blind eye by keeping the evidence to himself. Investigation revealed that the fingerprints lifted on the scene of crime on Fannie case 651 of 3/2014 positively linked the suspect, who's one of the suspects arrested on Musina 203 of 10/2022. This is the cash in transit docket, and also Musina case 210 of 10/2022. This is the possession of a licensed firearm docket. To further prove that this same suspect was involved in Fannie case 651 of 3/2014 of robbery, the victim's service pistol was found in his possession during his arrest in Musina. Now, lastly, on that aspect, during further investigation, it also emerged that on the 14th of June 2024, the applicant has handed in exhibit at Brett's LCRC 160 of 6/2024, marked Musina 2010/9/2022, where he specifically requested that Warrant Officer Motau be the member to analyze those exhibits. The investigation at Brett's LCRC revealed that the applicant submitted the exhibits using Musina Case 2010 of 9/2022, whereas the scene report indicated that it occurred at Hartbeespoort Dam. This talks to that very same issues that the applicant or the appellant said the state doesn't have a strong case and the issues are for trial. My Lord,
Criticism is leveled against the decision of the magistrate that he used those dockets that you are referring to say that the appellant will interfere with witnesses if it's a result of being in possession of those dockets. Now I want to ask you this question, because Mr. Potential, I received your view that those people mentioned in those dockets have got nothing to do with the current arrest of the appellant. So you are the prosecutor in the matter, and I assume that you will be a prosecutor in the trial matter.
that's correct, my Lord.
I'm not a Sangoma, but my little knowledge of operations of your office. What is going to happen to people referred in those dockets?
My Lord, witnesses have deposed to affidavits.
Yeah, no, without the risk of disclosing the identity of witnesses.
Yes.
Because the criticism leveled here is that those people in the dockets got nothing to do with the fact that the appellant will intimidate witnesses.
My Lord,
So if they are not witnesses, who is he going to intimidate? Because reference was made to those dockets in the judgment.
my Lord, those particular witnesses are witnesses. They will be witnesses in the current proceedings. They will be, my Lord.
Yes.
We have stated many other dockets that are on record as per bail record from the lower court, and also the ones highlighted in our heads of arguments. I'm not going to get into each and every docket that we have actually stated there. And I want to jump to the issue of my Lord, the appellant, in terms of SABC 108, which will be the inventory of items that are actually given to the appellant or a police officer. These will be things that he uses on a daily basis as part and parcel of executing his duties. The appellant was issued with 60 rounds in terms of the record. However, he submits.
When was he issued with this? Because in a normal course of his duty, he has to fire firearms. He has to fire shots and other things. When was this issued? Because normally when you pass out from the college, you are given this, the police refer to as 108, where you will be given a pistol, for example, and 2 magazines.
My Lord, I'm not having that information as I address the court. However, the information will be in the docket as to the date on which he was...
No, I know the appellant doesn't take issue with that.
Okay.
But for my own sake, I want to understand, because if a police is issued with 2 magazines in 2012, when he's suspended in 2026, you can't expect him to bring those 60 or whatever 30 round of ammunition that he was provided with.
My Lord, the understanding how the investigating officer, explained is that if you use ammunition, you report. you report, my lord. And there are books that those particular items will actually be recorded on.
So if
And-
you have used, then you will get a replacement.
That's my understanding, my lord. But there are books that such information will be recorded on.
Yes.
And I'm told that there's also books that are used and they will be updated annually. However, my understanding is that when you use ammunition, you have to report.
Yes.
At the earliest opportunity, it has to be reported that you used ammunition and for what purpose. And I take it from there, that's when the replacement will be applied for
Yes.
or requested.
Yeah.
And there are also instances where they go to the shooting range for purpose of practice. And at the shooting range, this was also covered, that ammunition which is used at the shooting range will be provided there. And when you finish, you will get your ammunition back. In other words, you take out the magazine, you get issued with new ammunition for purpose of practice, you use it, you finish it, and then you take your ammunition back as it was. My lord, the interesting factor is that he brought 72 rounds back instead of 60. However, in addition to that, when he was searched, that's when more ammunition was found of R5 rifle, the rifle which he had already brought back upon suspension. And now the question, of course, which will be ventilated further in the trial court to say, what would have been the purpose of him keeping all this ammunition which belonged to subs? And there's a witness here, my lord, I think it's Resant, Sergeant Resant. I'm not sure whether it's Sergeant, but there's a witness that received these items when they were brought back by the appellant.
But what are the circumstances that led him to be in possession of this rifle? Because according to the 108 inventory, he was not issued with that rifle.
Well, it's not clear at this stage. However, if I can just have a second. My lord, the part of the R5 is that according to the rifle register, he booked it out.
Yeah, but is it there in the bail record?
In the bail?
Record.
No, it's not.
Yeah, but you mentioned the fact that it doesn't fall under 108 inventory. Why don't you deal with that aspect in your affidavit? That it was booked out for a particular purpose.
But look, we didn't charge him for possession of the R5.
No, I understand, but you are alleging that he was found in possession of an R5 rifle. He was in possession, in fact, of an R5 rifle, which he returned. But according to your inventory, there's no record that he was issued. Why do you mention that?
No, I didn't say that, my lord. I spoke about ammunition.
I'm talking about your affidavit. You mentioned him being in possession of the R5. When he was suspended, they returned it back. And then according to the inventory, 108 inventory, it's not one of the weapons that he was issued with. Unless you don't know your affidavit.
No, that's not what I That's not what I argued, my lord, in my list of arguments.
Yeah,
You didn't
that's why-
speak about that.
That's the question that I raised.
I don't remember
Forget
that
about
part.
the person who's next to you.
I don't remember that part.
I'm not saying you mention it. I'm asking questions relating to that R5.
Oh, okay.
So why didn't you deal with that aspect that it was booked out? Hence the fact that when he returned the state equipment, you also returned this R5 rifle. You only mentioned that it was not issued with it in terms of the inventory.
My lord, there's a statement of Risang that was attached. It's part of the record.
Risanga.
Risang, I'll... Just a moment, my lord, I'm just getting...
Yes, Mr. Mpatle.
As the court pleases, I found the statement, my lord.
Yes. Is it part of the bail record?
Yes, my lord. The statement of Rossi Resant,
Where do I find it?
it's page 91 of the paginated in Bern. Yeah, it's page 91, my lord. The writing is not that legible there, but it's page 91.
Yes.
Rossi Resant, who is a brigadier in the South African Police Services attached to Organized Crime Investigations, Division Detectives and Forensic Service at Section Head Operational Task and Project Investigations at Wagday's building in Pretoria. Paragraph 3, that's where indicates that an R5 rifle with the serial number 350871 was returned by the appellant.
I don't have an issue with that. Go to paragraph 4 of that statement, of that affidavit, I'm sorry. The second line. You said the R5 rifle, however, is not in his SAP S108, and I can therefore not confirm the number of rounds he received. Are you listening to me, Mr. Mpatle?
Yes, I am. I'm looking for the paragraph.
The R5 rifle, however, is not in his SAP S108, and I can therefore not confirm the number of rounds he received. So my questions are stemming from this paragraph where it is said, I don't have a problem that it was returned back to him. My concern is just, why didn't you deal with this aspect that these are the circumstances that led to him to be in possession of that R5 rifle, because it was not issued to him in terms of the inventory list.
I get what my lord is saying. I guess it was
Yes.
an
So
oversight.
your argument now that he booked it out is argument outside the bail record.
I hear what my lord is saying.
Yes. Yes, you may proceed.
As the court pleases. Now, my lord, dealing with that issue of ammunition now, that this particular ammunition, number one, it was not issued to him. Number two, he did not return it. Clearly, it was marked ammunition belonging to SABC. My Lord, the appellant says or said that, or they made a submission that it was within a very short space of time, that from the period when he was served with a suspension, returned to the items, to the period when he was searched. The date of the search and seizure. But it is our submission that that argument does not hold water. The fact that on the other side he says he was told not to access the building or come closer to the building. Rosie Resant indicates that when she received, or when the appellant called her, bringing these items back, the items that were brought back, he called her and went to the basement. So clearly, the accused had all other options, the appellant had all other options to communicate with his employer to make sure that he makes these particular items available to them. He brings them back to them. However, he did not actually use that particular option. Clearly, he knew what he was doing.
Yeah, that's the point that I forgot to raise up with Mr. Potgieter. Because according to the statement, there are certain items that he promised to return at a later stage. The router and other things that he didn't have on that time, on that day. So my question was, how was he going to return that? Because they're raising an argument.
That's another point that I was going to raise, to say, Rosie, that is Brigadier Resant, clearly said that an arrangement was to be made with the appellant to bring back the other items that he did not have in his possession at the time, the ones that officially were allocated to him as per 108. So it goes back to my submission to say he had all the options in the world to bring back these particular items. And clearly his intention was to keep them, and therefore goes to that point where we say he stole these particular items. They were stolen because they are nowhere appearing on the records of SABC as having been given to him. I'm talking about the ammunition now that I'm saying belongs to SABC, which he did not bring back. And there was also the issue of the leg irons. Now, the appellant also brought an issue about the money that was found in his possession.
What about the leg irons?
Were not returned.
Pardon?
He was found in possession of the leg irons.
Yes.
Yes. And these leg irons are the property, or is the property of SABC. Clearly marked. Now, the issue of the money. He was found in possession of that huge amount of cash. No issues were taken up with authorities.
So what happened to that confiscated cash? Was the case opened or what?
An inquiry docket was opened, my lord.
Yes.
And then in connection with the second one, he also decides to be very silent. He hasn't addressed that issue. He's quite on it.
Wasn't he exercising his right to silence?
My lord.
Is he not entitled to remain silent?
My lord, this is where now the issues come, because if you decide to exercise your right might not actually be absolute. This is where certain rights are limited, because it might work against you.
You're not
that
charging him with section, is it 36 or 8?
And POCA also provides for that, my lord. Acquisition, possession, and ultimately you don't have an explanation or reasonable explanation why you are in possession of such a huge amount of cash. My lord, it is our submission that the court assessed, there is the bail court, assessed the prima facie strength of the state case based on the affidavits, the exhibits in form of photos that were extracted from the photo album by Warrant Officer Ndumiso, as I indicated. The court made a pronouncement that the state had established a prima facie case against the appellant, and therefore they had a strong case.
Mr. Pretoria says it must not be on a suspicion. It must be substantiated by clear evidence.
My lord, what was presented, we're not talking about information that has been thumbsucked here. We're talking about exhibits that are in the docket, and some have been made available to the court for the bail court to make a proper pronouncement. We've got witness statements that have already been taken, and some of them, I think we stated as to which witness statements we are referring to. Yes. And at the later stage, even if they have to go and refer, the record will so reflect. And when they get access to the docket, they will be able to compare, and they will see that this information was not thumbsucked. It was indeed evidence that was collected by the investigating officer. And on that basis, my lord, we as the state or respondent have a very strong case against the appellant.
Yes, can we pause here and take a lunch adjournment?
As the court pleases.
Sorry, are you finishing? But Mr. Potitas must reply to your submissions as well. Can we take 45 minutes?
As the court pleases.
Or is it too small? Some other people like pap. So you must take a full hour to eat pap. Is it fine, ma'am? Is it fine, 45 minutes? Yes. Where are the orderlies? 45 minutes, is it fine? For Mut? 45 minutes. And don't complain. Court agents.
All right.
the court pleases. My Lord, I would like to move to a correction of one aspect in the exhibit. I've got a photo which is in color, which clearly shows what is what. When the court requested us to provide the photo number of the stun grenade, I erroneously indicated that it's 611. In terms of the color now, color photos, it's 612.
Did you show it to?
I would like to make this available to the court, as the court pleases.
This is not additional information.
No, it's not.
Is it not on that premise?
Yeah, it's in the record.
So you said you made a mistake?
The stun grenade, I had indicated that is the photo that appears at the top. Is the photo that appears at the bottom on your extreme right.
Next to a pepper spray?
Yes, next to a pepper spray.
Yes.
As the court pleases. My Lord, I would like to then address the court in respect of the assessment of the risks that are contemplated in section 60, subsection 4, the grounds for opposing bail. My Lord, the lower court or the bail court dealt with these aspects, and on the aspect of endangerment of public safety, there is section 60, subsection 4A. The appellant was found in possession of multiple firearms, large quantities of ammunition, and an explosive device, which is prohibited by the law. Loaded firearms were stored in an unsafe manner and not in accordance with the law in a household where there's a minor child, and therefore that shows that the public safety, there is a public safety danger that is associated with that or with his conduct. The bail court pronounced that or found that the appellant would be a danger to public safety if he were to be released on bail. Well, I will come back just to touch on these aspects. Going into the third one in particular, interference with witnesses, in terms of section 4, section 60, subsection 4C. The appellant's knowledge of the investigative methods and or procedures and access to police network as a police officer places him in a position where he is likely to interfere with witnesses. The appellant was found in possession of police dockets and sensitive investigative material, which creates a reasonable apprehension that he has the propensity to interfere with the witnesses, investigations, and evidence to be used against him. The appellant knows the identity of all the witnesses and is most likely to interfere with them. In Richard case 671/01/2013, the appellant was in lawful possession of the docket and didn't send the suspect's fingerprints to the LCRC, and as such defeating the ends of justice. The bail court correctly established that the appellant had the propensity to interfere with witnesses and in investigations. And I would like to talk to subsection 64D, which pertains to undermining or jeopardizing the criminal justice system. The unlawful possession of police dockets relating to serious offenses, unexplained possession of subs, ammunition, and equipment shows a pattern or conduct inconsistent with duties of a police officer. The bail court correctly found that if released on bail, the applicant may continue to undermine the proper functioning of the criminal justice system. The court established that the appellant had failed to provide any satisfactory assurance to the contrary. The onus was on the appellant to discharge this ground. In terms of section 60, subsection 4E, on disturbing public order or public peace, the appellant is a police officer. He was found in unlawful possession of the exhibits as indicated, confidential police material and suspected links with organized crime or criminal underworld. The release on bail under the circumstances would undermine public confidence in the criminal justice system. The bail court correctly found that the appellant had fallen short of discharging this onus. As recognized in authority, the public confidence is a critical component of the administration of justice. In S versus Yanta,
S versus?
Yanta, Y-A,
Oh, Yanta.
yeah, Yanta, 2000, volume 1, SACR 237 in brackets TK, the court confirmed that a bail court is required to prognosticate and assess future risks on the information placed before it. In Diale, State versus Diale, and another.
Diale.
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 Excuse. In States versus Diale and another, 2013, volume 2, SACR GNP, the court held that a bail court must make findings on probabilities. The learned magistrate accordingly acted correctly in evaluating the evidence and probabilities before it. Now, on the issue of probabilities, the court looked at the probabilities to the appellant's explanation and weighed it against the evidence presented by the respondent and found that the appellant's version was improbable. For instance, the fact that he was found in possession of police dockets, equipment, and ammunition which belonged to the state, but fell short of providing a satisfactory explanation of why he was still in possession of the exhibits, even when he was on suspension. Evidence was presented of the items that he returned upon his suspension and the items issued to him by subs before his suspension. He promised to return some of the outstanding subs items which were properly issued to him but never did. The appellant was never issued with a stun grenade and the extra subs ammunition which was for the R5 and for the 9mm firearms, which he was found in possession of. The only inference under the circumstances is that he stole those particular items. The court correctly found that his version is or was improbable. Now, on his failure to discharge honors, the appellant bore the honors in terms of Section 60(11)(b) of the Criminal Procedure Act to satisfy the court or court ACO that the interest of justice permitted his release on bail. The affidavit and notes filed on behalf of the appellant contained broad constitutional propositions and general denials, but lacked material detail regarding several crucial aspects of the appellant's personal circumstances and explanations relating to the evidence allegedly recovered. The present appeal cannot, or bail appeal, cannot serve as an opportunity to supplement deficiencies in the original bail application through argument or factual contentions not properly placed before the court ACO. Court ACO cannot be faulted for failing to consider information which was never properly placed before it by the appellant. The strength of the state case against the appellant is strong. The evidence before the court included the following: firearms and ammunition, the explosive device, police dockets, and subs-related material. Amongst others will be the leg irons, cash allegedly constituting process of crime, and an objective documentary and a photographic evidence. The appellant's denial regarding the stun grenade was contradicted by objective evidential material placed before the court, including photographic exhibits and the investigating officer's affidavit. The learned magistrate was entitled to reject the bold denial in light of the objective evidence before it. In State v. Falyun, 2002, Volume 2, SACR 550, Supreme Court of Appeal decision, the Supreme Court of Appeal recognized that the strength of the state case remains a highly relevant consideration in bail proceedings. Now, regarding the risks contemplated in Section 60 of the CPA, the appellant contends that there is no evidence that he interfered with investigations or witnesses. That submission misconceives the nature of a bail inquiry. Section 60 concerns the likelihood or risks of interference and not proof that interference has already occurred. In State v. Matebula, 2010, Volume 1, SACR, page 55, Supreme Court of Appeal decision, the Supreme Court of Appeal confirmed that the inquiry concerns whether the interests of justice permit release. The learned magistrate correctly considered the following aspects: the appellant's position as a police officer, his access to sensitive information and investigations, his knowledge of subsystems and procedures, and the nature and seriousness of the allegations against him. The respondent does not contend that the appellant be treated differently merely because he's a police officer. However, his position, training, access to sensitive information, knowledge of investigative processes were properly considered by the court ACO insofar as they increased the risks contemplated in Section 60 of the CPA. The aspect of material misdirection, we submitted there was no material misdirection by court ACO. The judgment of the court ACO demonstrates a careful consideration of the applicable statutory provisions, the relevant authorities, and the constitutional rights of the appellant. The magistrate expressly excluded media narratives and matters outside the record for consideration. The appellant's grounds amount largely to dissatisfaction with the conclusions reached by the court ACO rather than demonstrable misdirection. The learned magistrate considered the evidence holistically, applied the correct legal principles, and exercised her discretion judicially. There exists no basis for appellate court interference. My Lord,
There is an attack on a credibility finding made by the magistrate.
my Lord, it is my submission that
And then on that suspect, Mr. Potgieter is saying that he misdirected herself. Because that's a premature finding, according to him.
my Lord,
That is a trial matter.
I respectfully submit that the court had to make a finding based on the information that was placed before it. The appellant made certain allegations,
No, I don't have a problem with that.
made bad denials
For the-
in the face of evidence that was presented. For instance, about the items that were found in
Yeah,
the
but was
house.
she competent to make a credibility finding in this stage of the bail application?
My Lord, the magistrate,
I know where you are coming from. You said there is evidentiary proof
yes,
to show to it what is the circumstances relating to, sorry, to the safe. But the attack or criticism is to the fact that she was not competent at the stage to have made a credibility finding against the appellant.
my Lord, the magistrate could not ignore what was placed before her and the allegations made by the appellant in the face of the evidence that has been presented by the respondent. Bad denials, for instance, there's no way in which the court could have just ignored that. The court had to comment on that. Yes, one can argue as
The fact that she made a credibility finding before the trial matter could commence, doesn't it affect this right that he was hammering on, the right to innocence?
my Lord, it doesn't. I respectfully submit that it does not. This is not a trial court as the magistrate, the length magistrate indicated. The pronouncement was merely for purpose of bail, whether it was in the interest of justice.
No, we are on the bail stage.
Yes.
We are not yet to trial. That's why Mr. Potgieter is saying that that finding is premature.
My Lord, I respectfully submit that under the circumstances, it wasn't, because, as I said, they introduced evidence which was contrary to what the state had presented, and pictures.
Which evidence is that?
Which evidence? I would give an example, my Lord, of the stun grenade.
No, we are talking about, she made a credibility finding with regard to the safe. Is it not so?
Yes,
She says no, there's photos which proves the position of the, so she made a credibility finding as to why should the appellant denies that allegation.
my Lord, if we go to the record, we argued that based on what the appellant said and also what we presented, the bail court had to make a credibility finding on that aspect because there were two.
So are you saying a bail court is competent to make a credibility finding? Is that your argument?
Yes, to a particular extent, I will respectfully submit so, my Lord.
So under what circumstances is the court competent, bail court competent to make a credibility finding?
My Lord, evidence was introduced.
If you lie under oath, is it what you tend to mean?
I would say so, my Lord. If it's clear that what has been said cannot be true, given the fact that evidence has been presented and photographs clearly show what the evidence portrays, whereas on vis-a-vis the statement by the appellant which says something else, and it's not substantiated by anything. It was just a mere allegation. So on that basis, I would say yes, yes, my lord.
Contention.
I cannot address the court.
Not out of hand. You don't have it readily available.
Which one, my lord?
Authority supporting your submissions.
No, I don't have it as I speak. My lord, before I go to closing, there were 2 or 3 aspects that the appellant raised. I noted them somewhere. I just want to quickly go to them. My lord, the respondent does not dispute the importance of the presumption of innocence and the constitutional right to liberty. However, the Constitutional Court listed few authorities: State versus Dlamini, State versus Ladla, and others.
It's one decision.
Sorry?
It's one decision.
Yes. State versus Tibet and State versus Kitekat.
Yes.
Where the court recognized that those rights are balanced against the interest of justice in bail proceedings.
The magistrate recognizes that right, but it says it's limited.
Yes.
On my proper reading of a judgment.
Which I concur, my lord, with the learned magistrate.
It's not an absolute right.
It's not absolute. It's limited.
Doesn't it offend on the right to innocence?
Does it?
Doesn't it offend on the right to innocence?
It doesn't, my lord. Not at all.
Yes. Yes.
Just checking the last aspect that I wanted to. My lord, the judgment by the bail court demonstrates a detailed consideration of his personal circumstances, his constitutional rights, and the applicable section 60 factors before the court ultimately concluded that the interest of justice did not permit his release. My lord, the state, in respect of the fired cartridges, does not rely on the fired cartridges in isolation as a proof of criminal conduct. They are relevant within the context or contextually to the broader firearm-related circumstances discovered during that particular search.
But it's not charged with it.
Yes.
Is there any offense for keeping a fired cartridge?
No, my lord, that's what I'm saying. Within the context. We're arguing on the other side about danger, public safety. Clearly, the and also on the possession of unlawful ammunition. Clearly that the appellant's access to all this particular ammunition to a greater extent poses a threat, because clearly in his possession we find used cartridges, and we cannot tell what he used those cartridges for. He did not also say much about them in his affidavit or in his application in Kotako. He was silent to a particular extent, and therefore one cannot leave that alone. And when one mentions it, when the respondent mentions that it's within the context of firearms control, Firearms Control Act provisions. Yes. So it did not contravene a particular section per se, but it is my humble submission.
Do I understand your case to mean that at the time of the search, the appellant was legally represented?
My Lord, it is correct that during the search, the appellant was given an opportunity to contact his legal representation.
Was it before the search was conducted?
Before it was conducted.
Yes.
And they availed themselves, they arrived at the scene. And also, I remember one aspect. There was one aspect that was also raised, that the camera was moved or moved away. Nothing much was actually said as far as substantiating that particular point. To say what were the circumstances, what is it that the police were avoiding, and it was not mentioned when counsel was at the scene, that allegedly the police officers moved the cameras away. So, yes, my Lord, legal counsel was present for the appellant at his premises when this search was conducted. Yes. My Lord, in conclusion, I respectfully submit that the appellant has failed to establish that the learned magistrate committed any material misdirection or exercised her discretion improperly. The findings of Court Akko were rational, evidence-based, and properly grounded in Section 60 of the CPA. We therefore pray that the appeal be accordingly dismissed. There's one aspect that I highlighted here, my Lord, that I forgot to mention. The appellant, I think is in paragraph 89, indicated that it is further submitted that
of what?
of their aids of argument, appellant's aids of argument, that the appellant is not a wealthy person who's able to forfeit bail money paid and or who has the means to leave the country. My Lord, I submit that on the contrary, as much as we may not argue that he's a wealthy person, but he's got access to cash, he's got access to money.
You have taken away that cash.
It was taken away for the first time, but it was there the second time.
Yes.
So, clearly he's got his own ways of making money, and not just small cash. We're talking big money here. I mean, 300 and something thousand. It's not a child's play. Having more than 50,000 in your household is not something that is common. And we're talking about someone who declared his salary as being in the region of 16,000 rands. We're talking about someone that hasn't actually indicated anything about having business interest. I think somewhere he said that he doesn't have business interest outside South Africa, even locally. I don't remember him indicating that he's running a business which generates cash on a daily basis. And therefore, it is my humble submission on that aspect that he's moneyed, he's got cash.
You mentioned that the wife is gainfully employed.
That's correct.
As a traffic officer, if I'm not mistaken.
That is correct, my lord. He indicated that, yes, his wife is a member of TMPD, Tshwane Metropolitan Police, and he's got one child, and clearly it's business as usual at home because the wife is gainfully employed. There's no one starving as we speak. And it is my submission on that aspect also that the denial of bail for the accused would actually be detrimental to anything that he has at home. Just a second, my lord. My lord, unless if the court would like to engage me on several aspects from my side, I rest my case, my lord.
Yes.
As the court pleases.
Mr. Potgieter, before I'm going to afford you an opportunity to reply, there's one aspect that I omitted to deal with you when I raised certain issues with you. The issue of passport. On your client's version, where's that passport?
It's in possession of the legal representative who appeared for him at court. My
Yeah,
lord,
but according to his affidavit, what is he saying?
there's two, in one paragraph in the affidavit says it's been handed over to the investigating officer. That's in paragraph 37. In paragraph 41 it says it will be handed over to the investigating officer. So, like I've also indicated in my heads, there is a contradictory version about that in the affidavit. But that is clear, my lord, because immediately after the state's affidavit, the legal representative who appeared for him said to the court, yes, both passports I've got it in my possession. I'm in a position to hand it over to him.
Is he still on brief?
No, he's not on brief yet.
So what is he doing with somebody else's passport?
He had it for that, oh yeah, my lawyer is in possession of it now. Both he and court now today. So he had it there to, obviously, to hand over if there's a need for that, if the court decided that he must hand it over.
Yes.
So, my lord, I submit that that's actually a neutral aspect because of the fact that the passport is available. and immediately
Yeah, but
turned on.
it's now, you are placing it from the bar.
But it was also the same situation at the time before the bail court granted or refused the bail.
Where?
In the record it is, my lord. that
In the argument.
it was
No,
immediately.
the argument is not
Yeah.
evidence.
I know, but the passports was available. That's all that I want to say. So it's not something that's hidden or not available or an issue. It is still, even today, it is available, and we are in a position to hand it over to the investigating officer. So
Why didn't they depose to a supplementary affidavit?
I can't say, my lord. That's unfortunate, and I can't take that further.
Yes.
My lord, is there any other question that my lord
No,
have, or can I just
do you want to reply to?
I do.
Yes.
I just want to make 3 short comments.
Yes.
My learned friend placed a lot of score on the strength of this case, and they've got a very strong case. That's the wording that he used. My lord, I want to refer his lordship to page 141 of the bail book, where the learned office said the
Is it
following.
paginated or the record?
No, to the red bail.
Oh, your authority.
Ja, van der Berg. Toe
You are
van
so
der Berg.
obsessed with Van der Berg.
Ja. Can I back in 19 record? My lord, the learned officer said it should be cautioned, however, that the strength of the state case is but a factor to consider and can never by itself constitute a bar to the grant of bail. After all, even those who admit guilt are eligible for bail.
Can you just repeat what you have read?
What it says, my lord, it says it should be cautioned, however, that the strength of the state's case is but a factor to be considered and can never by itself constitute a bar to the grant of bail. After all, even those who admit guilt are eligible for bail. So that is exactly what it is, my lord. So it shouldn't be an overriding factor that says, and I got actually the impression that my learned friend says, no, there's no way for this this appellant to actually plead not guilty, and because we've proven our case already. That's the impression that's created, and that should never be the impression.
That's applicable because we have people who have been convicted and sentenced but are permitted to bail pending the appeal matters.
Correct, my lord.
Yes.
That's on appeal get bail, where they sentenced to serious Schedule 6 crime, my lord.
And you can be denied bail before you are convicted
Yes,
or before the trial commences.
correct. That's
Yes.
also true. My lord, and then just the other factor that I just want to mention, and that is the one about the camera system that my learned friend referred to,
Yes.
my lord, and what the appellant said, he said the camera system was switched off. So, and that is the end of it. You know, that's evidence from him. He said it was switched off. So, my lord, whether his attorney then came and said nothing about that, it doesn't really take the matter further for the state. His evidence is it was switched off. Then I just have,
But what is the effect of that?
what is the?
Effect.
Well, the effect thereof is just, my lord, that they say that it was never raised. So, as a defense, that
No. I'm talking about this affirmation
yes.
that the cameras were switched off
Well, it's clear from his affirmation.
because it doesn't say this search was unprocedural or irregular.
Well, that is what it hinted to by saying that the camera
it doesn't
system
say
was
so.
switched off.
It just said no cameras were tampered with and switched off.
Yeah. So
Yeah, but what has that to do with the search
Why-
that was conducted?
why would you say that if you're confronted with a search and allegations about firearms that were found and a stun grenade, which you deny, Then you say the
Yeah,
camera
but it
system.
doesn't deny the legality of the search.
He doesn't deny that there was a search. He denies that what was found in the search.
Yeah, but the legality of the search he doesn't deny. He doesn't contest.
Well, my lord, I submit that that is an indication. I accept what his lordship said. It wasn't directly stated in the affidavit. But my submission is that that's a pointer in that direction.
Yes.
My lord, just on the one point of the access to money and so forth, my lord, I want to take his lordship back to Wilkinson's case and to paragraph 6 of that matter. And in that matter, the court said the following paragraph 6. A further misdirection is the approach adopted by the learned judge in respect of the appellant's substantial assets. Jordan J. regarded the fact that the appellant is a wealthy individual as a factor against the granting of bail. The appellant, he said, would have no qualms about forfeiting any amount of bail fixed by the court, given the severe sentences he faced. This reasoning is, with respect, illogical. It would mean that wealthy individuals would face an extra hurdle to overcome, particularly when they apply for bail in serious cases with charges which carry severe penalties upon conviction. These misdirections constitute an improper exercise of the High Court's discretion. We are thus at large to consider the question afresh. Now, my lord, the only reason why I refer to that is that the magistrate even made a lot about the fact that he has some access to money because there were 50,000 rand found there, and that could be a method to place himself without the or outside the area of the court and the trial court. But in Wilkinson, the court will say that would be an extra burden. So it would also be, my lord, and I also want to draw a distinction with that, with the fact that because he's a police officer, or let me rather rephrase to say, because he's a suspended police officer, that he knows investigation methods and that should be held against him. It means that it follows that if we apply the principle in Wilkinson that any police officer that is arrested must have an extra burden to prove to be granted bail, and that could never have been what the lawgiver intended. And then just lastly, my lord, I'm done.
Yes.
I just want to revisit I've read something, and I just want to draw his lordship attention about the bail conditions. In paragraph 7 of that decision, my lord, the court said, there is a further compelling reason why interference on appeal is warranted. The High Court failed to give any consideration at all to the imposition of suitable conditions as an alternative to refusing bail altogether. This too constitutes a failure by the High Court to exercise a proper discretion. In any bail application, regardless of the nature of the charge or charges, the point of the departure in deciding whether not to grant bail is section 351F of the Constitution, which provides that, and then the court proceeds from that. So the court clearly, the Supreme Court of Appeal clearly found that it was a misdirection if you do not consider bail applications as an alternative to the denial of bail. And I submit that there is an abundance of posts that would have been able to deal with the fears of the state in respect of the appellant to be granted bail. Thank you, my lord. That concludes.
Yes. Councillor, I'm grateful for the submissions and the heads of arguments that you have presented. So I'm now full. You have fed me with a lot of information. I'm going to reserve this judgment. But I promise very soon I'll deliver the judgment. So once the judgment is ready. You'll be apprised of the date. My registrar will get in contact with you. And then, that's it.
Please, court.
So this judgment is reserved. Court agents.
I'm not scared of you now.
Why is it?